Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are going to talk about an application brought by some plaintiffs to bring a derivative suit on behalf of a couple of companies. So let's sketch out our fact pattern and find out what the court had to say about it. Right, our plaintiffs are shareholders in two companies. One company is what we might call a trading company or an active company that is out in the marketplace selling fire collars and other things in relation to the building and construction industry. The other company is a trustee company, and what that company does is hold on trust the intellectual property assets that are needed by the trading company in order to go about its business. So we have this trustee as well as the trustee of a unit trust. So our plaintiffs today are shareholders in the trading company, shareholders in the trustee company, and unit holders in the unit trust, of which this trustee is the trustee, and which contains that IP property I mentioned earlier. Now, the issue for us today is that the plaintiffs have some complaints about the defendants. Now, the defendants are the directors of the trading company and directors of the trustee company. And the plaintiffs have these various complaints. Now, these complaints arise in part after one of the plaintiffs ceased their employment relationship with the trading entity in about 2014. And from about that time, there's evidence before the court that allows it to form the view that there was a real disgruntled, sort of challenging relationship where from about the time one of the plaintiffs was removed from employment, the plaintiffs were not particularly impressed with the way the affairs were being run of that little group. So what the plaintiffs particularly complain about in this case is two broad issues. One of them is they say that the defendants, in their capacity as directors, have caused the trustee to raise capital in a way that dilutes their shares and their unit holdings, to use that capital to purchase from the trading entity some valuable assets, and then to license back to the trading entity on uncommercial terms those assets that they got out of the trading company and put into the hands of the trustee. So broadly speaking, that's one of the complaints. The other complaints the plaintiffs raise is the idea that, and the fact that, the defendants founded a new entity, and that new entity essentially sold similar sorts of products to an overseas market, and then caused our trading company to provide those products to our new company, and for the new company to trade overseas. And then in respect of some of the works of the new company, they caused the older company to do those works, and to do so based on a fee that the plaintiffs say was uncommercial. And essentially what the plaintiffs are saying is this is all a big problem caused by the defendants. And so what the plaintiffs say is we want leave to bring a derivative action, a derivative suit, which is to say we want leave to sort of clothe ourselves legally in the company and the trustee company and to sue the defendants in their capacity as directors for breaches of their directors' duties, for breaches of contract and breaches of other duties. Now, importantly, there are other parts of the claim as well. The plaintiffs also say, look, we want to raise the issue of breach of trust caused by these directors, and we want to raise the issue of corporate oppression, section 232, 233 of the Corporations Act. So let's just bear those in mind as we work through the derivative suit part first. Now, as you and I both know well, when you're thinking about bringing a derivative suit for a company that is not in liquidation, you want to turn to section 237 of the Corporations Act, and section 237 subsection 2 has the 5 criteria you've got to meet, and the criterion that really exercised the court's mind in relation to this application was best interests. So the real fundamental question for the court today was, is it in the best interests that the plaintiffs be given leave to sort of stand in the shoes of these companies and to bring actions against the directors? Now, importantly, one of the key considerations when the court is considering is it in the best interest of the company to grant this leave is the question asked of the plaintiffs, well, is there some other avenue that the plaintiffs could pursue? Is there something else the plaintiffs could do to get similar relief without forcing the company to bring this litigation in circumstances where it obviously doesn't want to because it's not doing that? And the court considered particularly the oppression claim that you might remember I mentioned a little earlier. Now, corporate oppression, as you and I both know, is about shareholders, members, getting a remedy, and that remedy will often, and not always, but will often take the form of a buyout, a forced share sale at fair value. And what the court did was highlight this as a potential alternative claim. The court went on to further note that any calculation of the buyout sum that might be granted to the plaintiffs in relation to this oppression relief could necessarily include a value that dealt with these issues about the alleged breaches of duty from the defendants. And so that means that on one view, and indeed on the view that is eventually adopted by the court, any relief that is obtained by the plaintiffs from the oppression suit could incorporate a relief arising from the misconduct, the alleged misconduct of the defendants in relation to these transactions. And what the court goes on to say was, well, in circumstances where they can get similar relief without forcing the company to run litigation it doesn't want to, it's not in the best interests of the company to bring the claim. And so in circumstances where the plaintiffs had not shown that corporate oppression relief would be inadequate, it was not appropriate to grant leave to the plaintiffs to bring a derivative suit on behalf of the companies. So the plaintiffs lost. They failed in their claim in relation to derivative action because they had other avenues open to them, including the avenue of corporate oppression. I hope that discussion assisted you, and I look forward to speaking again soon over another coffee and in respect of another case note. Cheers.